You're listening to the Valley Current.
This is an educational meeting. The idea is really to give people a sense of where topics are going in the law that also provides some good context for intellectual property, learning intellectual property, learning different cases. So what I did is I forwarded a complaint that was filed in the federal courts as a good example of what's happening in intellectual property law because of things like ChatGPT, which, as we all know from various discussions we've had, is a large language model AI tool that allows things to happen that perhaps as short as just 3 to 5 years ago couldn't easily happen on a computer, but now is automated in a way that's producing some amazing results and also some amazing snafus with lawyers. And there's clearly lots of worry that many knowledge workers, probably lawyers included, are going to get swept in by these AI tools. And it's created a lot of concern about what happens to people with good educations and good skills that somehow cannot be easily justified at the level they're at, which of course means you have to move at some higher and higher level of providing better and better types of services over time. I mean, the thing I'll start with is a graphic that we've talked about before, just to set the educational stage. This is a graphic that was published by Singularity University on the course of human history. It's kind of interesting. I think I've shown it once or twice before because it says that we've seen, as the population has grown, we've seen, according to Singularity University, dating back a long time ago, things that occurred as inventions occurred over the scale of time. They're claiming they've gone back like 9,000 years. I don't know if that's really true. The graphic is just made to be illustrative. It's not really necessarily saying this is precisely how things occurred as the population got to the point of being 1 billion people. We know the population of the world is now getting to something closer to 9 billion people. Maybe it'll be 10 billion by 2030. But we had some form of discovery of, for example, a plow, and then irrigation, and then the first city in the world came about, they say, at something like 4,000 BC. I don't know if that's accurate or not. Metallurgy, writing, mathematics, these things were all discovered thousands of years ago. And with those various discoveries, various cities came into being, like the city of Rome in Italy, Athens in Greece. And there was the beginning of things like the agricultural revolution. And then you see the curve start to tilt up as we approach the 1900s or the 1800s, or maybe even the 1700s, with various things being discovered, various inventions happening over time, the Industrial Revolution happening, the discovery of the airplane and the creation of a mass market automobile, the discovery of various medical solutions like penicillin, and really the age of science coming into being, DNA being discovered, high-speed computers, which started, of course, as big mainframe computers. And then they put points on this, like man lands on the moon, and PCs come into being. And this is like the 1960s, I think, more of mini computers, but then PCs were 1970s. And then really the internet comes on the scene in the 1970s, but really it was more of a military academic thing called the ARPANET originally. And so it made its way from the ARPANET into what we know as the internet today. Can you guys all see the screen with this chart?
Yes.
This chart is sort of a way just to give you a framework for the acceleration of innovation over time. And you could argue maybe the inflection point was the discovery of mathematics. You can go backwards and say, no, maybe it's the discovery of writing. You can go forwards and say, no, maybe it's the creation of a city. And as people come together in cities, they start doing brainstorming and they start talking, what if this happened, or what if that happened? Or maybe you could say it's the discovery of mass transportation like railroads, or mass communications like telephone. I don't know where you would say the inflection point really was. They're suggesting it's somewhere at, I don't know what this is. It looks almost like it's maybe, the 1500s, but I think it's much more like the 1800s or even 1900s that we really start to see the acceleration of discoveries that make a big difference in terms of communication and in terms of ideas getting sliced, diced, multiplied, amplified, changed, adapted, created into other things over time. And you could say clearly on this chart where this arrow is, and they don't have it here, but they would have to add it, that we're now in the era of AI. Like, we're beyond the internet. We're in the era of a augmented intelligence. That's what I think of as AI, but you can call it artificial intelligence. We're in this era of intelligence being amplified or augmented with automation tools like ChatGPT, and there are many others too that are these large language model tools that were created as a result of the mass amount of information that made it to storage devices on the internet. When years ago, we had all of our information locally on a local hard drive, and it wasn't really shared, there was no easy way to create these large language models. But once you have lots and lots of information stored on multiple storage areas readily accessible to these scraping tools that can basically scrape information. And we should talk about what they're scraping, because that's at the heart of this lawsuit that was filed, I think, either yesterday or the day before. It might have been filed on Wednesday as a class action case against all of the various OpenAI companies. OpenAI, the website that we know that publishes ChatGPT and makes it available for $20 a month paid and free if you don't want the high-powered version. There's actually a whole bunch of other defendants that are in this lawsuit that I circulated, because I think this lawsuit is the beginning of the attack on everything that the large language model AI community is trying to do with all of the information that's stored on the internet. And I'm not going to take a position on whether I think it's good, bad, evil, whatever. I'm going to just say that generally, probably OpenAI anticipated that some of this litigation would occur. They probably didn't anticipate as much of this litigation as they're going to get, or as they already have gotten. And I think they're probably going to have to grow a pretty big legal department and probably have to hire lots of law firms, maybe even more than Facebook or Google have hired, so that they can deal with what will be a repeated attack around how they're doing business and how they've decided to do business. Because in general, they are believing they can leverage information that perhaps might be questionable of whether they can leverage it or not. This information is on the internet and available, but it's not declared to be public domain. So the very first thing you have to think about is, what does it mean for information to be readily available, published, and not public domain? Like, what does that mean? What does it mean that stuff is on the internet, sometimes with a copyright notice, sometimes not with a copyright notice, sometimes without other identifying information about whether it's protected or not, sometimes with identifying information that it's protected in some form? I mean, we're talking about a massive amount of information. A lot of it is advertising, and a lot of it is marketing. So a lot of it is not really information that was ever meant to be subject to any type of protection. It was information that welcomes republication. It's almost like, sure, do whatever you want, make it repeat itself. I want to get as many hits or as many likes as possible. So let me just pause here for a second and ask for any questions that folks have about sort of where we are, how we got to this place, and then we'll turn to the actual lawsuit that I circulated that was brought by these two authors. One of them lives in Massachusetts. The other one, I think, lives in Canada. They both are novelists. That is, they write novels for a living. They're authors. They publish their novels, typically through traditional media or traditional publishers, but these days it's mostly then sold through Amazon. Amazon's a distributor of the books, and the books are on Amazon and available. One of them is $5, another one I think is 10 or 15. And the argument that's being made is that ChatGPT must have absorbed the entire content of the book and is spitting back a summary of the book when people ask. Now, I don't know how they know that people have even asked. Well, they've asked. I mean, they, as authors, bought a ChatGPT account or got a free account, decided to type in, and we'll look at the query that they actually typed in, and they got an answer back. Now, how they got that answer back and what was actually used to generate that answer is going to be a very interesting forensic question that's going to come up. But let me just pause and ask, does anyone have any questions or comments about this sort of background information leading up to the lawsuit that we'll look at? Any comments or questions from anyone? I mean, Nikki, are you use ChatGPT or have you not used ChatGPT?
I have never used ChatGPT. I mean, I know that there was an instance at my school where people would use it during their timed writes, and they will like put the prompt in and it'll generate an essay, but I've never used it.
But your school, like others, probably has some rules about.
Yeah, we had to do handwritten timed writes after that, which is so much worse than on your computer.
Wait, say that again.
Because people were using it for like timed writes on their essays and everything, we had to start doing handwritten ones. So we do have rules against it at Notre Dame.
Oh, because people were actually using it electronically that your school went to, you're going to handwrite an essay instead?
Yeah.
Wow, that's interesting. So what happens to people that don't have good handwriting?
I think that they're a little lenient on handwriting for timed writes, because sometimes with timed writes, I think we would have like 35 minutes. So
you're calling it a timed write?
Yeah, they give you a prompt, and then you have 35 minutes to write an essay on it.
So,
and that's in class?
Yeah, in class.
And so people, wow. I mean, couldn't they just block the access to the internet, like for that time period in class?
They can't block certain sites because Notre Dame, you can use your own laptop. They don't have like Chromebooks that you use. Like a lot of public schools, I know Aragon does, where they give you a Chromebook to use, and you can probably block sites on that. But because everyone uses their own personal laptop at Notre Dame, they can't block it.
Yeah, I guess they can't just like shut down the network like in specific areas. Like I'm just like in a classroom, like can they just block access to the Wi-Fi in a classroom? Because I mean everybody's on the school's Wi-Fi, right? Or do they have?
They can definitely block access to sites via the router. You're correct. They don't need people to use certain laptops.
I
Right,
guess
but they could have people,
hotspot.
but they could have people with cell phones that.
Yeah, you can connect to hotspot. We have to do that a lot because the internet just like goes off. So you can easily just connect to your hotspot and still use it.
I mean, it's a problem that just generally what we're talking about, again, is the class action case that was brought by two authors, Paul Tremblay and Mona Awad. I don't think they're related. One lives in Massachusetts. I think Tremblay lives in Massachusetts. Awad, I think, is a Canadian citizen that lives somewhere in Canada. They, as the class representatives, are purporting to represent, and I'm not precisely sure, we'll read it in a second, all authors of published books. Now, remember, ChatGPT goes into the internet and leverages, I'm just going to say leverages, whether you define that as derives, copies, somehow extracts ideas, like what it exactly does. Presumably this lawsuit will eventually uncover, but they brought a case. That's a class action case against all of these defendants, OpenAI, and then these various investment partnerships that have supported OpenAI Inc. Like there's OpenAI Delaware Limited Partnership, there's OpenAI GP and LLC, there's OpenAI Startup Fund. These are all like the financial third-party entities that gathered mostly private and VC investors to get this little company started. And it's going to be an interesting retelling of the history of how this company started, because I think it actually started originally as a nonprofit and then got converted into a for-profit company. But this class action law firm that's in San Francisco, Joseph Saveri Law Firm, in downtown San Francisco, he brings class action cases, and there's a lawyer in Los Angeles, Matthew Buderick, that must have known these two authors. Maybe he did some of the legal work for them. And their argument, and I can show you how simple this case is because we're going to sort of probe, can there be a class action case in a copyright scenario or copyright infringement scenario that's being discussed here? Because there isn't really a lot of extrinsic evidence of what ChatGPT or how many times ChatGPT has actually published any of their works or published a summary of any of their works. Clearly, ChatGPT is not republishing the entire 300 or so page book that Tremblay wrote, or the couple hundred page book that Aman wrote, Awad wrote, Mona Awad wrote. They're publishing a summary or they're publishing a synopsis, but other sites are also publishing summaries. Like Wikipedia has a summary for these books, as does some of these Cliff Notes services that are out there. They have summaries too, but I think the view of these authors is, well, those summaries are good because they help promote people buying the book, whereas ChatGPT's summary is, I guess, this is the argument, so detailed that people don't really even need to buy the book. But I don't know people that buy summaries of books to completely replace reading the book. They might buy the summary or read the summary.
If it's a textbook or like a school book, it could be. Maybe that's what this is about.
No, it's not a school book. It's not a textbook. It's works of fiction. So you could even say the class action itself has to be configured in a way that makes sense, because maybe certain authors of certain books would want summaries to be published, because like Peter Attia's Outlive book, which is like 500-600 pages, there's a bunch of different people that have published summaries on it. But my guess is Peter Attia treats it as, that's good. It's going to help get the word out for people buying the book and eventually going to his podcast and maybe becoming a paid member of his podcast, because the book is 600 pages. And reading the summary is a little bit like, do I want to invest the time in the book or the podcast or something else? But so there's many defendants. That's the first observation. There's two plaintiff representatives. They're both authors of fiction. I'll show you what the fictional works are in a second. But there's kind of an overview of what ChatGPT is, right? And what this case is about. They say just the authors of books, right, with registered copyrights. Well, we know most of the books, most of the time that are published, particularly books that are self-published, people don't necessarily register their copyright. Yet a precondition for filing a copyright case is the plaintiff has to have registered their copyright. So is this just the class members that have registered copyrights? Or is it class members for everyone that's ever published anything on the internet? Because copyright exists from the moment of creation and fixation of the work into some media, typically typewritten or text, words and that sort of thing that represents something on a file. And the file is typically a Word document if people are using Microsoft Word, or a Google document if people are using Google Docs. So they say plaintiffs and class members are authors of books. That's pretty general. Plaintiffs and class members have registered copyrights in the books they publish. That immediately probably cuts out 80% of the people that have published books, because most of them don't necessarily register copyrights.
But that is difficult. They're going to have an uphill battle trying to determine this, like who should be in this group, because you have to show that your facts would be the facts that can support all these other people. And if there's these massive differences, that doesn't work.
Right. It's not every author that's ever published a book, whether or not they've registered the copyright. They're saying, and I think they're doing this because they know that technically to file a federal case, and the U.S. Supreme Court decided this a year or two ago, you must first register your copyright, which is why it's good to register early, even as an unpublished work first. And then you can update the registration to say it's now published. And that gets you coverage, including if someone decides that they've gotten access to your unpublished work, as sometimes happens, and they beat you to the punch and publish it without your authority. That's still an infringement, but you have to have registered your copyright to be able to capture that infringement. So these folks are saying they're representing a class, it sounds like, of any author of any book. And then you have to define what a book is, right? Because does that include certain pamphlets as well? Does it include things that might be described not necessarily as books, like a play or poetry? I mean, I think it could be, I guess, a book of poetry. But it says class members did not consent to the use of their copyrighted books as training material for ChatGPT. Nevertheless, their copyrighted materials were ingested and used to train ChatGPT. So is that the act of infringement? The ingestion?
Oh, there's more. You're saying there's more to it than just searching. There were certain, all these books were used to do some, training? That I didn't realize that.
Well, that's the question. The first question is the act of ingestion, like reading something and not republishing it, just reading it. It's available on the internet somewhere. Now you have to ask, how the heck did it get available on the internet? Well, there probably are some illegal sites that have entire books. And because policing has not occurred, the plaintiff owner of the copyright is sort of allowing that unauthorized copy to exist. That's one way it could be true. The other way it could be true, I suppose, is there are some versions of Kindle books that are available for free. Now, I don't know whether Amazon actually allows ChatGPT to get to those Kindle books where they're effectively unlocked and free. There's no charge. But then the question is, what's the damage if there's no charge? If there's no charge, typically there'd be no royalty. If it's really a free book, it's almost like being done as a vanity book for publicity purposes. And there are many.
Well, it could be those things where you know how you sign up for something, but you have to, you say that I'm a student and I'm using this for just student purposes or whatever. And maybe they did that when they did ChatGPT. It's like, oh, it's just for educational purposes because they're training something, right? But that is not what that's intended to be. What if they did something like that?
Right. So immediately, and this was the heading on the email that I circulated about, is ChatGPT essentially a quote unquote fair use machine? Because paragraph 6, and it's not really a very long complaint. We're not going to go over every paragraph. Paragraph 6 says, defendants by and through the use of ChatGPT benefit commercial, probably should be commercially, and profit richly. I mean, this is where a real read out loud, what we call in the firm RROL, would have really benefited this complaint. It should read defendants benefit commercially and profit richly from the use of plaintiffs and class members' copyrighted materials. Why are they saying that? They're getting ready for the summary judgment on fair use. The complaint is being written anticipating that the major defense of the defendants will be, we're just fairly using what we ingest to allow some sort of summary presentation that actually aids the sales of your work. It doesn't take away from your work. It's like teaching people in a classroom about a work. Of course, you have to be able to refer to the work. Of course, you have to occasionally quote it. Of course, you have to say who the author is. You have to say who the title is. It's not trade secret. You're not violating any confidentiality. It's a First Amendment activity, which is really what the fair use doctrine is all about. The fair use doctrine, under the statutory provision of the Copyright Act, which is section, I think it's 107 of the Copyright Act, is meant, 17 USC 107, is meant to say, we get to communicate about various works. Indeed, if you ever watch any of these news programs, there's many of them, when authors come on, the author is interviewed in detail about a work, and the author will probably, in a half hour, expose the entire storyline of the work. So that's all been available also for ingesting. Now, was the ingesting of the original work, that is, can you prove access? Because that's what they have to prove. They have to prove access to the underlying work, as opposed to access to a summary that someone else put on their site, or an access to an interview where the work was discussed, or an access to a scholarly paper where the work.
They make it sound like it is access to the whole book.
Right. No, they're saying, I think their basic premise is the entire work and the entire work of the entire universe of all registered copyrights was accessed by ChatGPT in some mega way, like some mega munching millions, if not billion, maybe trillions of gigabytes of data. So then there's all these standard jurisdictional paragraphs. They obviously made a venue choice to file in the Ninth Circuit and to file in the Northern District of California in the Ninth Circuit. I think they probably could have decided to file potentially somewhere else. Now, maybe they didn't want to have a venue fight because clearly OpenAI has its main offices, I think, somewhere in Palo Alto, maybe somewhere else in Santa Clara County. So they decided to file the case. I guess they decided to file in San Francisco, but I think they might end up getting pushed to San Jose. Oh, this says OpenAI is headquartered in San Francisco. So clearly then in paragraph 9, they're saying the reason we filed in San Francisco is the main defendant, OpenAI Inc., is here in San Francisco. I don't know where all those other entities are, right? So then they give a background of the plaintiff, Tremblay. He lives in Massachusetts. He owns registered copyrights and here's the work, the cabin at the end of the world. And it contains a copyright management information system that includes the name of the author, the year of publication. And then the other plaintiff representative is Mona Awad. She lives in Massachusetts. Maybe they live together. I thought she was Canadian. At least the copyright registration says that. 13 Ways of Looking at a Fat Girl, as well as a second work called Bunny. Does anyone know these books? Because I've never heard of these authors and never heard of these books before at all. Does anyone know of these books or these authors?
No, but I mean, I don't really follow fiction, so.
Right. So then
I've
they
never heard of them. I read a lot of fiction books. I've never heard of these people.
right. I mean, I'm not thinking that they're, necessarily on any New York Times.
Maybe that's why they use them.
Well,
ChatGPT.
Well, ChatGPT could obviously take complaints and then, I guess, flip a switch and say, if someone asks about Tremblay or Awad, we have no information about them. I think that may be a solution if we're trying to brainstorm solutions here for the plaintiff. Maybe they should be a little bit like what happens to other online companies like Facebook. I mean, that's going to be another issue, which is, can they defend this case on some view that they're protected by Section 230 of the Communications Act? I kind of doubt that they can, because they have control and they're the ones that are producing the output. It's not really a third party that is producing or posting information on a platform. They're actually doing their own kind of regurgitation of information. So they don't actually put in the body of the complaint the registered copyrights that are at issue, because the truth is, it would be a lot of registered copyrights. The Exhibit A is just of those 3, but they're using the class action technique to say there's going to be a long list of registered copyrights that represent authors that never consented to ChatGPT and therefore are owed presumably some type of royalty. But I don't know how that royalty would get calculated, because ChatGPT is probably mostly free. It doesn't charge by the search. It charges for $20 a month for access and for use for all sorts of things, right? People are using it for all sorts of public domain activities. So it's not like people are buying it specifically to get at registered copyrights of authors of fiction or authors of copyrighted books at all. So the unfortunate thing is these guys did not actually include the registration. At least the copy of the complaint that I have doesn't show Exhibit A. So I went to Pacer and pulled up the Exhibit A as well as the Exhibit B, because you're going to see that, when we get beyond the preliminary allegations, the way they decide that there's something here to complain about is, and they tell the story of large language models and how they work and what versions of ChatGPT have been out there and how long it's been out there. They give a little bit of the history of it over and over again, which I think is interesting history to read and to try to understand, to get a flavor of what's going on here. But what they say, and I want to get to Exhibit B, which is really their demonstrative proof. They say when ChatGPT was prompted to summarize books written by each of the plaintiffs, so that's 3 books, it generated very accurate summaries. These summaries are attached as Exhibit B. Now, this is a little bit like the opposite of the recent case we saw where the lawyers got hallucinated versions of case law, and those lawyers got sanctioned under Rule 11 for citing cases that didn't exist. This is the opposite. They're saying ChatGPT was actually very accurate. The summaries got some details wrong, but the details are highlighted. This is expected, blah, blah, blah. They're basically saying still the rest are summaries are accurate, which means that ChatGPT retains knowledge of a particular work in the training data set and is able to output similar textual content. At no point did ChatGPT reproduce any of the copyright management information, meaning the copyright notice, which plaintiffs included with their work. So that's like an attribution argument, that there should have been some attribution given and maybe even a link to Amazon. Then we're turning ChatGPT a little bit into a marketing function, a little bit like the summary stuff that's out there. So let's just pause there and ask, if we look at Exhibit B, does it matter how detailed it is that it came back? Does that really matter for proving infringement? Or are these folks really saying, well, they must have ingested the entire book. We're drawing an inference from the output that they ingested the entire book, and that was the copyright infringing activity.
Is their complaint just that they weren't referenced? I mean, because that could be true, whether or not it's that accurate or that detailed. I mean, they should put an attribution. I think just like they should have those little warnings that this, when they're doing legal stuff, this is not, I am not an attorney, I'm a AI, and not, this isn't legal advice. I mean, for the same reasons, they should do those attributions where they put
that's an easy fix, right? That's a pretty easy fix. But we know class action lawyers seek a lot more than easy fixes, right? Class action lawyers typically want to get money. They're typically financed by litigation lenders who want to see their investment of whatever partial hourly rates that they're paying generate a return. Typically, it's a pretty high return.
So we're looking at a statutory penalty or something?
Well, that's one angle. I mean, one angle would be some view that it would be some type of statutory liquidated damages per work, per infringement, or per episode of infringement. And if it's $15,000 per work and there's 1 million registered works that got ingested, copyright registered books that got ingested, and the act of ingestion, as opposed to the act of actually producing the summary, is what generates the infringement. And you could say it's 15,000 a pop if it really is that high. That's a huge amount of money. If it's $1 billion,
it's a common strategy in these class actions to, the statutory penalty thing. I mean, you're going after that a lot of times.
Well, I mean, it could be a much lower number than that, maybe as low as I think 500, but still, if there were just,
it still adds up.
Still a big number, because if there's 1 million published works at 500 a pop, it's $500 million, right? That's a big outcome for ChatGPT ingesting, if that's what the complaint is. Now, here's what the evidence is. This is Exhibit B. I pulled it from Pacer. Exhibit A was the Copyright Office registration information. Exhibit B is Tremblay. The prompt was really simple. Summarize in detail the first part of, quote, The Cabin at the End of the World by Paul Tremblay. Now, that's a pretty simple 15-word prompt with the exact title and the exact author. And the command is just summarize, and the output is psychological horror novel, opens with an intense premise, and then it kind of goes through 1, 2, 3, 4, 5, 6 paragraphs of summary, right? And no attribution. I mean, no specific copyright, see with the circle 2018 or whenever Tremblay came out with this book. Now, you could probably find a summary of this book that is available through a Cliff Notes type of summary. Now, I don't know, I can't judge easily whether this summary is so detailed that somehow it takes away from the idea of buying the book. The book is 300 pages long. Is this 6-paragraph summary, maybe if there's, I don't know, 60 words per paragraph, let's call it 360 word summary, if it's even that long? Is this really going to commercially destroy someone's desire to read a 300-page novel? Is it really going to change the behavior of someone that's interested in Tremblay's books? Because I want to compare for a second, because I did this exercise before I started the Zoom.
I'm not sure that's the argument, because if they just want to be listed like as the author, they're not saying that no one's going to read it. In fact, they might think that someone would, but not unless you give them the author.
Well, the prompt had the name of the author there, but your point is it should have been repeated? It should have been repeated in the answer?
No, I'm saying, isn't that their argument? They're saying there was no attribution, or no, that's what they're saying.
They're bringing the attribution claim because they're using a separate part of the federal Copyright Millennium Act provisions that talk about copyright management information. And they have a separate claim we'll get to, separate from the Section 106 infringement claim. They have a separate claim that essentially goes to attribution. But here's Wikipedia, the free encyclopedia, summarizing The Cabin at the End of the World, right? This 2018 horror novel by Paul Tremblay. It received certain awards. It was adapted into some sort of movie called Knock at the Cabin. And then it gives a plot I haven't compared it, 1, 2, 3, 4, 5, 6 paragraphs as well. Now, I haven't compared these 6 paragraphs with the 6 paragraphs. I guess somebody could do that. We could theoretically grab these 6 paragraphs. I think this is legal to do, but maybe someone would say it's not. You can grab these 6 paragraphs, and you can grab the 6 paragraphs that ChatGPT does, and you could say, did ChatGPT leverage off of Wikipedia? Because we do know that ChatGPT did ingest or does ingest Wikipedia, and maybe they didn't ingest the entire book. The premise of the complaint is that the entire 300-page book was ingested and that the summary is being created from that book, not that the summary is being created off of the Wikipedia summary.
Wouldn't they have checked that, though, before they filed this lawsuit, you would think?
I don't know. I mean, different lawyers do different things, and different lawyers want to believe different things. They seem to have as their premise that the entire book was ingested. But even if it was, let's just assume it was. If there is a summary in Wikipedia or on Cliff Notes or in some scholarly lecture that made its way on the internet, and that summary was used by ChatGPT, and that summary was cross-compared against the underlying book by ChatGPT as a way to make sure the accuracy of then the newly derived summary that was derived from apparently a summary that these authors didn't complain about. Is that actionable as a copyright case? Do you follow the question? It's like, what's the real source of the summary, and what represents essentially a fair use on top of another fair use versus what represents a commercial use that violates the Copyright Act. I mean, this is very similar to the discussion that we had about the photograph that was done of the Purple Rain guy. What's that guy's name? The artist that used to be known as
Prince.
Prince. Right. Remember the photograph case involving
Andy Warhol?
Yeah, Andy Warhol, and whether or not that photograph should have resulted in a derivative work payment because it basically leveraged off of a black and white photograph to create a new form of art. And the Supreme Court, I think, ended up saying it wasn't a fair use, that there needed to be a royalty paid. It's a little bit like, where's the line between fair use and a commercial use that's actionable and justifies a royalty? That's the question. I mean, that's the way to think about what's presented here. Now, they don't diffuse these arguments. I don't think they do in the lawsuit. At least I didn't get the flavor in my first read of this complaint that they're diffusing that argument, that they're diffusing the use upon a use upon a use kind of argument, because a lot of stuff gets published on the internet, right? I mean, there's a lot of information on the internet, and there's lots of sources for information on the internet. And both of these works have other summaries and other sources of summaries. I just showed you the Wikipedia summary that also happens to be 6 fairly lengthy paragraphs. And that summary, 6, is probably more than 360 words. I haven't compared it in detail, but to me, it looks, just by first naked eye, it looks to me almost as detailed as the complaint as the Exhibit B is detailed. To me, they look somewhat similar, but obviously you'd have to go through and look specifically at that exhibit and decide, well, is it different? Is it more distinct in some ways? Is it more general in other ways? Like, how close does it come to sort of going over the line? So do you get my point about there's an archaeological dive that will have to occur here into how is this summary getting generated? And what is it getting generated from? And what should have been inspected by these lawyers? Like, how much testing should they have done to figure out what was really going on? And could they even have done it, even if they wanted to do it? So let's turn to the next one. They do this several times. I don't know why. They do it a second time, I guess, to see whether or not the same summary comes back.
I think they're doing different parts of the book.
Oh,
so
it's
like Spark Notes, where you can get just like a chapter summary. That's what they're doing, because it says summarize in detail the next part.
Oh, the next part, I see. Okay.
It's like different, which is that's probably why it's different from the Wikipedia summary.
Yeah.
So I would compare this to Spark Notes rather than Wikipedia, because Spark Notes has a chapter
in the olden days. But yeah.
So your point is Spark Notes is also online and does allow this kind of segmentation of the next part, the next part, the next part. And then you're getting way more than 360 words.
Spark Notes also has an analysis. So like I would like, if I'm reading a book for a school and I want to like refresh my memory before a quiz, I would look at the Spark Notes, because at the end, it also has an analysis on stuff that happened, whether that be a symbol or anything like that. I don't know if this is doing the same thing though.
Is Spark Notes, Cliff Notes, did they just change their name?
They're 2 different sites, but both do the same thing. Cliff Notes, I think Cliff Notes can be more detailed though than Spark Notes, but they both exist and they both have the same thing.
And they're both online, right?
Yes, I can pull up Cliff Notes and Spark Notes.
Yeah, pull it up and bring it on the screen in a minute, but let me just finish this exercise of Exhibit B. So the ending, summarize the ending. So their point is, when you get done with this kind of summary, maybe this is the proof of it's not the summary of the summary, because look how detailed it is. It goes way beyond what's in Wikipedia and maybe even way beyond what's in SparkNotes. I guess someone would have to do and have a subscription to SparkNotes, because you have to buy, what is it? Like,
You don't have to buy either of them. You don't even have to have an account.
So let's do this. Let's do, just as an exercise, if we can do it.
I don't know if that book exists though.
It has to be.
So you pay per the one you want? Because I mean,
No.
it used to be back before you bought the Cliff Notes.
It's the Cliff Notes and Spark Notes. They're both free. I just don't know what books I don't know if they have like every single book. Yes. I know that they have a lot of the classics. They have Shakespeare. They have Shakespeare translations as well. But
Shakespeare's in the public domain. So Shakespeare is the easy case of there's no copyright, because copyright expires, life of the author plus 70 years now. So, that copyright expired long ago. So to the extent it's public domain work, of which there is a large body of work, obviously, that's fallen into the public domain. Right.
They have a lot of books that you would read in school. So Jane Austen, the Bronte sisters, Frankenstein, Shakespeare, Lord of the Flies. They have like those kind of books on there. So I don't know if they would have this book, because I've never heard of it. So I don't think that I would read it in school.
Well, we'll do that exercise in a second.
School.
We'll do that exercise in a second. So bring up your SparkNotes site, which I guess is free.
Okay.
And he works off of advertising. To answer your question, Elizabeth, my guess is they're flashing ads for different study aids.
Oh, okay. I was wondering.
Yeah, that's the model.
Because you used to buy the book before.
Right. That's the model. So now this separate one is 13 Ways of Looking at a Fat Girl by Mona Awad. I looked it up on Amazon. It's available for $5. It's not a very long book. And they say summarize the first part. So they're going through and saying it's 1, 2, 3, 4, 5, 6, 7 paragraphs. Summarize the next part is, 1, 2, 3, 4, 5, 6, 7 paragraphs. The next part, they ask you the next part, 1, 2, 3, 4, 5, 6, 7. Maybe they always do 7 for some reason. Then they go to the next one, Bunny. They didn't ask for the ending though here, did they? The last one they asked for the ending. They just said the next part. I don't know why they weren't consistent in saying the ending. But it looks like it's in total 21 paragraphs of summary that is presented in Exhibit B. Now, if you look at I'm going to say Wikipedia. No, not the Wikipedia. The eNotes. I went to eNotes on this, and you could say, well, that's not as good as SparkNotes. So I'm going to ask you to put up the SparkNotes. But this is the online summary thing called eNotes for 13 Ways of Looking at a Fat Girl. Last updated January of 2022. It says the word count is 1871. So that's not a small word count for the summary. The book itself is 224 pages. It says, I thought it was much shorter than that. But it says 13 Ways of Looking at a Fat Girl is a collection of 13 linked short stories that follow Elizabeth, the young woman who spends much of her life hating her body. Elizabeth goes from overweight to thin, but while her weight loss earns her the approval of others, she seems increasingly unhappy with herself. Now, we'd all agree that summary is not actionable. It's just too short. It's too descriptive. It's too hard to believe that summary is somehow eroding a sale of this book, right? I think we'd all agree to that. I think we'd say, come on, that's a pure First Amendment, right? First Amendment exercise about what's this book about. And if we went to Amazon, we'd probably find a similar descriptive statement about the book. which is it's helping a potential purchaser decide if they want to spend any real time with this book. In fact, Kindle typically gives the entire first chapter of a book for free as kind of you get to kick the tires and look at it before deciding whether you want to invest the time in it, right? So then they go through, I guess, another 1,800 or so words of who are the principal characters and what happens. And then it does something that goes to another review site saying Kirkus Review called it painfully raw. So it's doing more description. It almost looks like a New York Review of Books kind of summary or review. It's got some detail to it. As it says, it's 1,871 words. I don't know then they give the review sources. Like there's other places that have commented on 13 Ways of Looking at a Fat Girl, right? Various review sites that are cited here in this eNotes, in this particular thing. So eNotes is kind of maybe a more scholarly form of SparkNotes. You tell me what you think, Nikki, because you're familiar with SparkNotes, and then I'll ask you to put SparkNotes up on the screen. They also have a place to have questions and answers. I guess this could be a community that gets built around people that are analyzing this book. Oh, no questions have been asked yet. So that kind of tells you probably people aren't really necessarily analyzing this book. But why don't you put up what SparkNotes does before we wrap up? Because this case is going to be a model for lots of other class action cases. Because the fact that one set of representatives for one type of book or books, if you can even say that there's enough commonality among all of these registered copyright holders, which they say didn't give consent, there will be other class action lawyers that will jump on the bandwagon and will try to define a class in a different way or a subclass in a different way. And that leads to what's called multi-district litigation in the federal courts if a case gets filed elsewhere. And indeed, that's why there's sort of a first mover advantage to being the first law firm to file, because then you can become lead counsel on all of the consolidated cases. And this is, to some degree, like a major, major liability risk, because OpenAI has to budget for the defense or insure for the defense, which may well be what they did. They may be well insuring. So can you put up your screen, Nikki, of what SparkNotes is?
Yes.
Or SparkNotes doesn't have?
I'm not sure. I didn't look up those two books because I already had it open to Lord of the Flies, and then I just pulled up the Cliff Notes for Lord of the Flies to compare the two. But this is what it looks like you can click on these to go to the chapter summaries of each chapter. And then it has the list of like main characters that you can look through, themes, questions, quotes. And then there's like some
that's a lot of summary. I mean,
yeah.
That's a lot more summary. I don't know if there's a button that says print it all out and how many pages you would end up getting, but I have to
probably a lot, because it has the summary of the whole chapter 1, and then underneath it has the analysis. And then Cliff Notes is like the same thing, summary analysis, and then chapter 1. It has the summary, and then there's more of like an analysis.
Well, just for the sake of seeing if these books even made it to the Cliff Note stage, I kind of doubt they did. Why don't you put, what is it called? 13 Ways. What was that one called? 13 Ways to Do a Fat Girl, or 13 Ways to Be a Fat
Look at a fat girl.
What is it called?
To look at a fat girl.
13 Ways of Looking at a Fat Girl.
Of looking. Oh.
13 Ways of Looking at a Fat Girl. Looking at a Fat Girl. Okay.
I don't think. Oh, nope. I don't think
it brings up an ad. Okay. So then the other one is called Bunny, Bunny. Kind of doubt if they don't have the 13.
Who's it by? Oh, they don't have it. These two sites mostly have books that you're probably going to end up reading like in school,
Right.
like those kind of classics, because a lot of students use these, or at least where I go, a lot of people.
Yeah, the market. Your point is the cabin at the end of the world would be the last one to test on both Cliff Notes and Spark Notes. You think that probably if it's not on Cliff Notes, it's not on Spark Notes, but they may not be identical, right? But they're looking at how many copies are sold and how many students are interested, right?
Spark Notes doesn't have it, but I can check Cliff Notes. Cabin at the End of the Woods.
Yeah, the cabinet at the end of the woods.
Okay. Neither one of them have it.
Yeah, the cabinet at the end of the world. Sorry, the cabinet at the end of the world.
Oh, okay. Let me.
Yeah, the cabinet at the end of the world.
Still doesn't have it.
Okay. So what's the view on, let's just take the simplest version of this case, just from an analysis point of view. What's the view on whether these plaintiffs can win? Let's focus on just these plaintiffs. Forget about the class action stuff for a second. Can these plaintiffs, these two plaintiffs with these three books, can they win this case against ChatGPT? In other words, when you just look at the question that would go to the jury, which is, do they own the copyright registrations? Yes, they do. Did the ChatGPT system have access? Because you have to prove, basically in a copyright case, similar to a trademark case, you have to prove ownership of the copyright. They're going to be able to prove that. And you have to prove infringement in the case of copyright infringement. And that breaks down to two things: access to the work and substantial similarity. Substantial similarity between the work that has been registered for copyright, the 300-page book, and the infringing whatever, the infringing summary, the infringing, in the case of an actual illegal copy of the book, it would be like a photocopy of the book or a photocopy of substantial portions of the book or quotes from substantial portions of the book. Now, taking ideas from the book, they're viewed as not necessarily infringement because you have to be infringing the expression of the book. You have to be taking something that is not just the idea of the book, but something that's the expression. And there has to be substantial similarity between the expression that's infringing and the expression that is subject to the copyright protection. They're effectively saying the summary is over the line of substantial similarity to the copyrighted expression of the book. That somehow it's more than just that one sentence that I said, clearly that one sentence summary, that's not a problem. That's just a high-level description of the type of book that it is. So any views on this? I mean, ownership is going to be proven. I guess access is going to be open because I imagine that the defendants will say, we access lots of other things. Maybe we access something that happens to have an illegal copy of your book on it. You should police that. We just grabbed it because it was on the internet. There's a lot of stuff on the internet that probably shouldn't be there. But we also looked at all these other summaries. And we looked at a lot of other stuff. And summaries have traditionally been unpoliced because we see that in various ways online. So does anyone have a view on whether you think there's going to be a success? And before we even get to fair use, because fair use is a defense. And fair use is going to be, okay, if we took some of your expression, we think there's a fair use defense because we're basically doing something that educates people about these books in ways that is, the words that are used in this area is transformative. we're transforming the work, like in the case of the Prince photograph. The main fair use defense was the colorized version that was done by Andy Warhol's foundation was a transformative re-expression of that photograph in a way that was a fair use. So let's get beyond the class thing and leave the class thing out, because I think the class thing is going to be heavily litigated about whether there really is commonality here or whether there's too many differences that exist between the class and individual members. But just looking at the first cause of action, which is direct copyright infringement, they're saying, look, you were never authorized to ingest, I think that's their view, harvesting mass quantities of textual material from the public internet, including plaintiffs' books, made copies during the training process. These are like interim copies, retain those copies, and basically presumably regurgitate them. So do you have any view on this, Taylor? What you would say if someone asked you, is this a copyright infringement? What would you say?
Jack, I'm not sure. I've been having some difficulty following this. My internet's been going in and out. I apologize.
Okay. What about you, Elizabeth? What would you say if someone asked you?
Well, as my typical answer would go, I feel like I need more facts. We're not talking about whether or not you're just talking about these specific books.
Yes.
Right. Yeah. I feel like I was kind of thinking, wait a second, what if you are copying an exact like summary of something else? Isn't that copyright, but of the summary too? That's what I was almost wondering. So, but that wouldn't be to the authors then, because, well, it could be if they wrote a summary. But where does that lie? That's where I was kind of thinking right now. I was like, wait a second, what about the summary itself?
Well, we know that people do summaries, and whether or not it's an infringing derivative work is actually the hot issue. And that is looked at around whether or not it's so substantially similar to the book, which means...
Could someone copyright the summary itself, is my point.
Yeah, I think they probably could. They would probably get a very thin copyright on the summary, on their expression of the summary, the way in which they actually choose to express the summary. But, at some point it's constrained. The summary itself is constrained by the book is the basis for the actual summary. So structurally, like a good example is SparkNotes lays out kind of an organized way. They probably do all their books, right, Nikki? And sort of the same.
That's what I was thinking of, actually. It was the Cliff Notes and SparkNotes. I was wondering if they copyright.
Oh yeah, they do for purposes of their, what they call their compilation copyright. They register the copyright in all the summaries, like it's one big encyclopedia of summaries, because their view is they're worried about a competitor that just copies all their stuff as opposed to an individual copy.
Right.
They're worried about a competitor that basically downloads their entire setup and then puts a different brand on it. So they want to be able to get the equivalent of a compilation copyright protection on the entirety of it. What do you think, Lin Yan, if you were the juror and you're looking at what was expressed in the summary versus the book? What would you say? How would you think about this?
I feel like I'm not on the side of the plaintiffs, really. I feel like it's hard to, because I've already looked it up. There's like websites that summarized both these books and they like provided summaries. So to me, it's a common thing on the internet to offer summaries of books. And I think it's in summarizing something, you're like paraphrasing. So it's a little transformative in my opinion. So that's just my belief.
Now, if a judge lets this case go, I mean, Nikki, what do you think? You're familiar with reading books and you're familiar with summaries, and tell me what you think. If you were a juror, how would you think about this case?
The way I think about it is all the books that I've had to spark notes just for like school, I own all of them. So that's not like, it's not like it's deterring me from buying them, because I spark noted Lord of the Flies, but I also read it too. So I have the copy of it. But then also, this isn't, regardless of the fact that the summary exists, I feel like this isn't the type of book that you're going to go searching for an in-detail summary about, because if you're wanting to read it, you're probably going to look up a summary on like Goodreads or something and read the reviews before you buy it. I personally, when it comes to, if I find a fiction book that I'm interested in reading, I wouldn't look up an in-detail summary on it to determine if I want to read it or not, if that makes sense.
Yeah, I mean, I think there's arguments that the reason companies like SparkNotes, Cliff Notes, Super Summary, and the rest exist because people actually kind of get into the community of what did you get out of this book? It's almost like for people that have read the book that want to see what other people have to say, right?
That's like Goodreads, but they don't have super in-depth summaries of the books. The summaries on Goodreads are basically the ones that you find on the back of the book, and then they just have people's thoughts that they can comment on like a blog.
Right, but look at Super Summary, right, which is a free site. It's got a lot of text about this book. I mean, once you subscribe, it does. It does a pretty detailed job. Now, I don't know if it's as detailed as what ChatGPT pumped out. And clearly at some point, I suppose, if ChatGPT, let's say for a 300-page book, were to create a 100-page summary, the odds are that there would be a lot of textual similarity. I mean, that's actually the question. Like, the summary is not word for word the text at all. The summary itself is an abstraction of the expression of the text. But how much of an abstraction does it have to be before it no longer becomes actionable? Obviously, if it's a one-sentence summary, that's a pretty generalized abstraction. And that's probably okay. I mean, the odds that one sentence are actually going to be viewed as an infringement. I mean, like this one sentence, tells us.
I think the points are that if they're saying that this is a full like you're essentially making it so people don't even want to read the book anymore, is that it would be like the equivalent of when you see those things written about movies, but you don't have the same issue with the movie because if you write something, it's not the same as what the actual art is, which is visual. But they have those disclaimers even where it says this has spoilers. Right. So in a book situation, it's writing to writing. And so if you have effectively that many spoilers, maybe then, you could see that argument. Because that's where I'm thinking, like, if I'm thinking of something I can think of as a good example of the equivalency of what they're complaining about.
Right. Interestingly, Super Summary says it's the modern alternative to both SparkNotes and Cliff Notes. That's what's on the right side here. So obviously there's an industry of doing these summaries, and that industry seems to allow for a number of competitors to all be competing with each other, presumably independently of each other without necessarily copying each other's work, but they're going back to the underlying work. Or they're commissioning people to go back to the underlying work and produce the summary. And so far as I know, most authors and most, if not all, publishers kind of are okay with these summary companies being in business on the view that it's more advertising for the book. And,
or in the case where she was pointing out, she did it for school, right? Always have the book first.
A lot of the authors that write the books that I have to read for school are dead. Like Charlotte Bronte, Jane Austen, Shakespeare, they can't really be suing anyone, which is why I think it's okay.
Their estate could for 70 years, and years ago it was 50 years. The estate of the deceased author, it's like in the U.S., copyright lasts a long time. Life of the author plus originally was 50 years. Then the Sonny Bono amendments extended it to 70.
They still have copyright though, those people's?
Yeah, I don't know. I mean, if it's from the 1800s, clearly not. If the person's been dead since whatever, 1930 something or 1940 something. I mean, every year that passes, more work falls into the public domain. That's the way to think about the business of ChatGPT. Can certainly still be in business with the store of public domain knowledge, because there still is a lot of public domain knowledge out there, right? I mean, there just is a lot of public domain knowledge, and it's falling into the public domain again and again and again. But now let's ask and wrap up with the more general question, which is, what happens if a court enjoins ChatGPT from ingesting or using any copyright registered books? And what if a court, because I think they actually asked for that remedy in the lawsuit, what if a court actually says, not just you have to put attribution, because that's a pretty easy thing to do, and probably they might even be able to get a preliminary injunction.
You don't think they are using the books, don't you? Isn't that what you were saying?
Well, that's what's unclear to me from what I'll call the forensic question of what is actually happening here. I don't think it's 100% clear that they're actually doing what these people say they're doing. I mean, maybe they are as a cross-check against other summary information, maybe. I mean, their argument is they're ingesting it and they're retaining it in some layer of what's called the convolution network, or what's called the layered network of how these neural nets actually work. So their argument is that retention in some storage of the actual text is itself a copyright infringing act, because that storage shouldn't really have that copy. It's like somehow if it did do it for the purpose of taking the facts or somehow extracting the facts, then the textual work should basically have disappeared to never be used again. And somehow just the ideas would have existed. There's other state law causes of action that probably are preempted by copyright law that's going to get thrown out. I'm sure probably on an early motion. There'll probably be some early motion that seeks to dismiss at least some of these claims for relief. But let me ask just the general question of what happens. They do ask for, they're not asking for any preliminary injunction. They are asking for a permanent injunction. But what happens if the court agrees? Let's forget about the damages and let's forget about the class action. Let's just say the court says, yeah, you can't ingest the text of these books without permission. Period, full stop. You can't do it. You have to basically buy some sort of license, sort of like the ruling in the Andy Warhol case. You have to upfront buy a license. And that means you may have to do a lot of license negotiations with a lot of different copyright owners for whatever length of time they're willing to license you their textual works, or else you have to eliminate those textual works from your database, right? I mean, what does that mean for the ChatGPT system? I don't think it puts them out of business. I mean, we could talk for a minute about whether the remedy that's being asked for, the damages remedy, could put them out of business. But
well, they don't need to access the books based on what you, because you don't even know if they are. And if they are, so don't use the summaries that are online.
Right. That's a question. What are they actually sourcing? Because there's a lot of information available online from other sources. And so far, those other sources haven't decided to take any action. against ChatGPT. I guess that could theoretically be another lawsuit. But in the worst case analysis, I think ChatGPT will have to then essentially fence off lots of different content. Now, I don't know if that's good for the world or bad for the world in a really big picture point of view. Is it good for the world or bad for the world that essentially access to that knowledge is gone in a system that maybe arguably in the big picture will sell more content? I don't know. But in a way,
that's
Google,
what IP is, right?
Sorry?
It's a limitation to get, that's what IP is in general. It gives someone it makes people want to create things because they're going to get a particular time where they get control of it. But then at some point it becomes public domain. So in time, it is going to be given to the world because yes, it's always a detriment, the initial IP, right? To the population, but the idea is that you get people to make these things because they get the right, and then it goes to the domain of the public domain after.
Yeah, I mean, your point is any injunction has to carve out that as works fall into the public domain, the order no longer applies. So that's sort of like almost a daily change, because every day someone hits their 70th anniversary after the death of the author. Or in the case of a corporate work, I think it's 100 years from the date of creation. But if you look at it, the remedy that they're asking for beyond the injunctive relief is actually statutory damages. That's F. Costs and attorney's fees, that's E. Pre and post-judgment interest. Court-approved notice program to give immediate notification of the class. I don't know. I mean, there's all sorts of expenses in this. My question is this: the Copyright Act says that the attorney's fees can swing both ways. That is, an award of attorney's fees can happen against a plaintiff as well. A succeeding defendant could also potentially win attorney's fees. Have the class action lawyers explained how big of a number that could potentially be against these plaintiffs if this lawsuit is lost? I mean, it's a novel question, so it's hard to believe.
What's the amount? I mean, well, it's because you would presumably win that immediately, right? Say this is a bad case. If they win, because if it goes on at all, then they've established that they had some basis to bring it, right? Because is that going to be the basis for them getting the fees?
Yeah, I mean, think about it as the case could be thrown out as a class action case because they could say there's too many differences between these authors about how important is their work, what's the volume of use of it, is the summary detailed enough, what gets generated as the summary for each of these other books, like how far do you have to go out and do some statistical analysis that the summary is just too detailed as opposed to a summary that's more general. And so there might be big differences between types of works, even types of registered works, even types of registered works of fiction, which these guys are saying all books of all types that are registered are what's covered under this lawsuit. And then the bigger question becomes fair use, because a judge could, on summary judgment, decide that this, as a matter of law, is a fair use and that it actually promotes the book. And that's why I think they're worried and they want to have this other issue, this digital millennium copyright issue about putting in the copyright notice under 17 USC 1203B1 to try to get that remedy, because that could be independently justified and probably easily done on every answer that comes back to every prompt. And so, to me, the interesting part is, does this class action case beget other class action cases against ChatGPT or against OpenAI, where everyone gets on the bandwagon and essentially says, hey, what happened here is an unlawful taking of copyright information. I mean, Google's never been charged with this, and yet Google probably does exactly the same type of ingestion, but they're not producing so far. Maybe Bard does. I don't know. I mean, someone would have to run a similar set of prompts on Bard because that's their competitor to ChatGPT. But conceptually, can you imagine a world in which somehow an innovation like ChatGPT gets scratched by litigation? Now, maybe the answer is no, it's just a matter of money. It's just a matter of having some sort of royalty tribunal that takes a certain amount of money and distributes it, just the way Google in Europe, I believe, has to pay certain publishers for the news content that it gets. And maybe it's starting to pay the New York Times and the Washington Post and other news organizations as well. And that's the solution here. But clearly on the big picture path of where is innovation going, I don't think there's any question that people are going to keep pushing the envelope of this graph that I showed at the very beginning, where they want there to be more content that is more readily available for everyone to be able to get to and to get to quickly in a way that allows ideas to manifest and to amplify and to be delivered and create new ideas for new books and new movies and new everything else. So, we'll wrap up on this thought, which is this type of litigation good? Or is this type of litigation problematic? And I don't know which judge is going to get assigned to this case, but I bet we're going to see different federal district judges and perhaps even different federal circuits. Maybe the Ninth Circuit will get the first crack at this, but I'm sure there'll be some cases that'll be filed in New York, and that'll probably be, Second Circuit, and maybe in other circuits like in Texas, the Fifth Circuit, and we may see a conflict among the circuits about how far does fair use go in protecting this type of innovation, because ultimately that's sort of the question that's wrapped up into this, which is this an innovation that should pay a royalty, or is this an innovation that really is supporting the ability of authors to get their names out there? I mean, clearly you'd have to have the person's name to put in the prompt to begin with, right? And I think if we put that name, Tremblay's name, into a Google prompt, we'd get some information about his book. Now, maybe we wouldn't get a book summary, but we would get something. And they didn't take any action against Google, right? So are there any further questions or comments about this at all? I mean, it'd be an interesting question. And I wonder, did they do any type of jury study to see how jurors would react to this case? Like, what do you think? Like, if you actually got a bunch of jurors in San Francisco, what do you think they would think about this case? I mean, that's the question. Like, at what level would they be offended? And at what level would they be like, what's the big deal? There's not a problem here. I mean, it's interesting. I just put Tremblay's name into Google and it showed at the very top a summary from Goodreads about the cabin at the end of the world, but it's a pretty short summary. It's not as detailed of a summary. It's like a couple of paragraphs long. So it's not anywhere near the level of detail. So are there any further questions and comments? And otherwise I
would just say, I think it would be depend on who you get in the jury box in San Francisco, because I could see a lot of people thinking like, what's the big deal? Being more, free and open access, and especially in San Francisco. I mean, I think it would just depend on who you got in the jury box.
So your point is there's a really important venue decision that was made. They obviously they chose it to be San Francisco.
Yeah.
That's, of course, a variety of different judges with a variety of different views, which means, of course, they chose Ninth Circuit, again, a variety of different panels with a variety of different views. And ultimately, look, if the class action part of it is stricken on the view that there's just too many differences between these registered works, that's going to make this a very small case, because I'm thinking that these books have not sold in mega volumes to begin with. And to somehow say that ChatGPT actually hurt the sales of the books, I think is a bit of a stretch for anyone to really imagine. So then the question becomes, do all of these summary services have to start paying a royalty? And what does that mean if students like Nikki can't get a summary anymore because the summary companies go out of business? I don't know, Nikki, why don't you put your final remarks in about how would you feel if you couldn't get a Spark Note about a book that you've already read?
It depends on the book, because if it's definitely like Shakespeare, because it takes sometimes reading for school can be on my last priority list, depends on what other homework I have. So I kind of, especially for Shakespeare, because you have to it's obviously written in iambic pentameter and it's very interesting to read. So I rely on those for the translation purposes. But for me, it wouldn't be the end of the world if Spark Notes stopped working, but it's definitely good to have a refresher before I have a quiz or something if I read it late last night,
Yeah, I mean, think of it that we're really in an era where ultimately these book summary people have to worry. I mean, they haven't been sued, but if they're thinking to themselves, well, look at what's happening here. ChatGPT is being sued. Now, maybe they're like, that's good, because ChatGPT is more likely to hurt our business than it is to hurt the business of the actual authors, because maybe the first thing you would do instead of going to a Spark Notes is go to a ChatGPT and ask it to do the summary and not even go to Spark Notes. Now, clearly, if Spark Notes doesn't have the book, then ChatGPT is actually providing a bit of a service if the world of summaries is a good thing. I mean, I tend to think the world of summaries is a good thing, and I think the world would be less valuable if we couldn't get summaries, because I read a lot and I tend to read the New York Review of Books to decide what I'm going to read next. And then I tend to want to look at how the book was reviewed. And I think if we lost those reviews, which often have detailed summaries of the book and lots of commentary, we're losing something of great value. But there are other people that would somehow think, well, you're going to lose an audience if you allow the summary. But to me, that's like pretty much saying that the discussion about a book should be curtailed. That's the essence of fair use and First Amendment. The discussion of the ideas in the book without necessarily engaging in lengthy quotes of any exact dialogue or any exact description, because that's really the protected expression. And most of the summaries aren't doing that. Most of the summaries are not actually quoting the books at all. I mean, maybe Spark Notes does, or maybe Cliff Notes does, but even in what I saw from ChatGPT, it looked more descriptive than expressive of here's exactly what the way in which the expression was revealed in the book itself. So there will obviously be many expert witnesses that will be comparing and cross-comparing what's in the summary. And that's the problem with the class action case, which is you can't automatically just assume that the level of granularity of what's in the summary is somehow substantially similar to what's in the book. It would actually take a fair amount of comparison, probably from an ordinary observer point of view, as well as maybe even potentially from an expert witness point of view, because the expert might say, look, this is all common stuff that you would otherwise find in the review of the books. And it's descriptive and not necessarily something that's viewed as protected. I mean, it's an interesting, it's really an interesting time in the history of artificial intelligence and where this is all going, because we're going to see many more of these lawsuits. And ultimately, it's going to be on the shoulders of, what do we have? 5,000 federal judges and I don't know how many appellate judges, 5,000 district court judges, and maybe, I don't know, a couple of thousand appellate court judges and 9 Supreme Court justices that are making policy decisions about how broad should the fair use doctrine be in an age of artificial intelligence. It's almost like we need some congressional review of what is the way to look at these artificial intelligence tools. And maybe that is what's going to be recognized out of all this, which is there's a much bigger congressional debate that should happen. And if it means that some small royalty or even maybe a large royalty has to be paid and the price of the monthly subscription has to go up, it's probably better that that happened than that the thing is just shut down. Because to shut it down means the world doesn't have a choice. It's essentially been turned into a, sorry, you're going to have to go on Amazon and buy the book, or else, you don't really get to even know what's the basic idea in it. I mean, that seems to me to be wrongheaded. And maybe ultimately it's an act of Congress or an amendment to the Copyright Act that has to go into play, which was not anticipated at the time of the Digital Millennium Copyright Act, although maybe it could have been. So maybe it's almost like the Copyright Act is going to have to be amended almost every decade, as opposed to, what we went from the 1976 Act or the revision in 1976 from what was originally the 1909 Act to then the Digital Millennium Act in 2000 that became effective in, I think it was 2010. So basically 50 years or so of the old act before we actually got to a new revised act. I think it's going to have to almost be like every 10 or 20 years, we'll have to have some consideration of new copyrighted issues or new issues under the Copyright Act and how they should be treated, as opposed to just leaving it to what will inevitably be an array of different federal district judge and federal court of appeal decisions that maybe eventually get harmonized by the Supreme Court, maybe not. I mean, the same thing has happened in protection of software or non-protection of software by patents under Alice versus CLS, which has festered now for probably the last 10 or 15 years without any congressional solution. And even that is another area where innovation is pushing the boundaries of what federal legislation has covered. So anyway, all of you should have a happy 4th of July. Hopefully we'll see you on Wednesday.
Tune in next time on the Valley Current.